We lost files, we lost most of our equipment because the river came in, the sea came in, and then the roof of the building, also that was lost.
So the court in itself, to be independent, must have a system that is robust enough to withstand any disaster.
We're moving towards a paperless judiciary.
A judge can walk with his tablet, access the portal, all the documents filed by the lawyers right there.
This change is good because the change is not motivated by one individual. It's motivated based on justice.
And so here is the official click.
The Eastern Caribbean Supreme Court is a regional court. The court is not a court in a single island. It is a court comprising 9 member states and territories. It's separated by water.
We also have different legal profiles of what we're really concerned with in each of these states.
You would have your magistrates court level, your high court level, your court of appeal level, with 9 registries and court staff ranging from 50 to 30 persons, each person with a specific task.
In each state, you have high courts that are operating, but those courts all come up to the next level, which is the Court of Appeal. And the Court of Appeal is basically centered physically at the court's headquarters here in St. Lucia.
The court is set up to ensure that every person has a place, a foundation to be heard, should they have concerns that need to be addressed.
Access to justice, what this is all about. It's not just the case of bringing a litigant to the courthouse to get his or her case heard. That's part of it, of course. And we have to keep the doors to our courts open and make them even more open.
And of course, ensure that it's done in a very fair, consistent manner to where their rights and their ability to be heard in a formal setting takes place.
What better way to connect all of the courts, the court offices across those 9 island states by way of a digital mechanism through the internet?
When one considers the role of the legal system in any society, it's critically important that the legal system and the institutions that comprise that system also make the shift and adapt. The ability to incorporate technology and make the court work more efficiently is fundamental to that.
But we're in the day and age of being digital, and the courts must adjust to that.
I think if we have a fully electronic integrated system, it will help us better to manage our filing system. And that will lend itself to better access to justice in itself. And to me, one cannot speak about the administration of justice if the ordinary man doesn't have access to the system.
It is critical. It is integral, because unless the public has confidence in the judiciary, in its fairness and in its integrity, that is really what gives it its not only its purpose, it is what gives it its authority. Authority of the courts must come from the people.
We are trying to be customer service oriented. We are trying to be as efficient as we possibly can. We are trying to change perspectives of how the court has been viewed for the last 50, 60 years, whether it's in our region or in the world.
And this speaks volumes, because we are seeing where technology has now become an integral part of how we communicate on an everyday basis.
We have gone from simply paper filings to electronic filings, and we've done that for a long time without really appreciating, I think, from the time everyone became comfortable with emails. The court gets emails, email filings every day.
These filings were then pulled into GEMS in the sense that they were either attached, if they were documents, and entries made into GEMS subsequently. So these two systems were not integrated.
The courts had taken the initiative to leverage what we would call open source technology or free technology, which was simply Google Docs. So that in itself gave us the comfort that culturally they are ready to move to the next step, where they would be wanting a more end-to-end seamless type of platform.
We thought that we should have an integrated system. So we looked around, we developed what we call our requirement specification documents.
What the court has been seeking to do is to look at methodologies by digitization of its processes. What that does is it allows for quicker research, it allows for quicker retrieval, and electronic filing and electronic case processing.
I believe it was March of 2016, we proposed to the ECSC a diagnostic study which would allow Crimson Logic to understand what is the current climate for the judiciary and their jurisdictions.
We had a number of demonstrations. They were listening to what we wanted in terms of the needs of our court and also what they had developed to date.
So what differentiates Crimson Logic's Judicial Accelerator? What it does allow is for agility as they grow, because they're a young jurisdiction. The platform will be able to grow organically with them.
So we've had to create a tailor-made package which can work for all of our territories and states. That means that it's going to take some time before we iron out all the wrinkles.
I think there have been challenges that the Eastern Caribbean Court has faced that has created delays.
There is an irreducible minimum of procedures that you can get rid of because of the need to give people a fair hearing. But if you can save time in that process, then you can avoid that horrible truism that justice delayed is justice denied.
There is a wide range of cases that do not require full-blown hearings in courts and so on and so forth, and that would massively benefit from a more fluid online process. And I'm not implying that the current judiciary is not, or the Eastern Caribbean Court is not efficient for the time being. It's just going to build on that.
And that's where the E-Litigation Portal comes in. It speeds up that which has been slow in our system to date. And if you can speed up the administrative side of justice, you're going to be doing everybody a favor.
What the E-Litigation Portal is doing is gradually taking us towards this paperless way of doing things, or how we'd like to refer to it as an e-judiciary.
So you'd have the litigants, you would have the lawyers, you'd have the case managers, you'd have the judges. With e-litigation, everyone actually comes on board.
It's a scheduling system. It's a filing system, which GEMS clearly isn't. So you have GEMS packed into this portal with so much more.
It is the entire gamut of the judicial ecosystem, from the time a lawyer or a natural person files a document to the time a judge concludes the case.
The e-litigation portal is a web-based solution that allows different parties, even the litigants, who can log on to a public inquiry search system and see when is the next court date. Simple as this.
And so here is the official click. Yes. There we are.
It's finally here. The ECSC E-Litigation Portal is now live for the Commercial Court and the Court of Appeal.
We have seen them take ownership of it. And the training sessions have been led by the ECSC IT team.
And it provides what we hope to be a safe portal where persons can file, pay fees, and manage their cases.
That in and of itself is a great achievement, because do you have to attend physically? at a court office to do that? No.
It means in the long run that justice will be accelerated, that people will have an end to their matters quicker.
What many people don't realize is that with a very straightforward standard application to the court, there are about 40 different administrative steps that need to be taken.
Every single filing that you take in, it must be recorded in a register with times, filing stamps, date stamps. You must deliver those copies again. Then you must take those, you must bundle them. They must be in a certain order. They must be in a certain folder. They must be filed in a certain order. So all of these things. So the staff, now you're going to be doing those things, but you are doing those things through the use of your computer. Importantly, not losing a document.
It removes the paper shuffling in a major way. That's why I started by saying we're moving towards a paperless judiciary.
You will spend less time looking for a filing cabinet in the judge's chambers or even in the registrar's office.
This system is now hosted on the Amazon Web Services on the cloud, which means it is open 24/7, anytime, any place, any device.
A mobile phone, a tablet, laptop, and so forth. So you want to find information on your case. You may not have internet generally home, but you have data on your phone or your mobile device. You can access that data.
What you have in this system, I think, is a good way for all our stakeholders to really be satisfied with a product that is just superb in its nature.
This stage that we are about to enter takes us to the next level in using e-technology. It is where we have to go. It is where we must go if we are going to remain ready for doing business, if we are going to remain responsive to the needs of the people that we serve.
Our courtrooms aren't getting any bigger and the volume of work is increasing.
A lot of work is done behind the scenes, not in the public side, in terms of preparation, hearings, reflections and writings thereafter to deliver a decision, sometimes overnight.
Our judges are hardworking, but they are limited in number. And if you look at the statistics and the number of matters that are heard and the number of matters that come before the court, and you stop to think, how could 3 judges hear all of these matters?
2017, let us just state that here, that would have been basically during the hurricane seasons, and we had court closures, but we yet had, for example, in the Court of Appeal, there was a total of over 800 matters filed. The court heard over 1,300 appeals, applications, chamber matters, and delivered over 800 decisions. In the High Court, we had over 7,000 cases filed in the High Court. So the volume of matters in the Court of Appeal reflects in every respect the volume of matters in the High Court that makes its way up to the Court of Appeal.
And when you have all of this action, you have all of these cases being filed, you have to have persons who take care of each case, whether it's a magistrate's court, a high court, whether it's criminal, civil, family, commercial, or it's a matter in the appellate court.
We do this, it's about 30 judicial officers across the 9 member states. In terms of the Court of Appeal, we have 6 members on the Court of Appeal, and that includes me as Chief Justice, as President of the Court of Appeal. It's a load that is higher, I think, than any other court in the region.
I think that we are absolutely doing the best that we can, but we're trying We're trying to strive for better, as everyone else does.
This is one of the reasons why we have to go to this method of electronic filings and also processing of your cases, because the volume, the time that it takes is tremendous.